Assalamualaikum and a very good day everyone. We are from Group 8 and today we would like to present about topic 8 which is the last topic of forensic accounting, resolution of fraud. So our content of presentation consists of 4 parts, which is the first part is a legal follow-up. Legal follow-up will be discussed on the court system and the litigation process. And the second part is with being an expert witnesses. We will see how accountant, auditor or fraud examiner play a role as expert witnesses. And the third one is general criteria and standard for evaluating an expert qualification. And the last one is question and answer. I'm Hakimah Binti Hamzah and my metric number is 252602 and I will explaining about legal follow-up. So before we understand the legal outcome of the possible action taken, first of all we need to understand the court system. So after being consult with lecturer, we decide to explaining the court system of Malaysia since we are more familiar with that. So this is the court hierarchy of Malaysia. It consists of two major parts, which is the Superior Court and Subordinate Court. Superior Court consists of Federal Court, Special Court, Court of Appeal, High Court of Malaya, and High Court of Sabah and Sarawak. Meanwhile, Subordinate Court consists of Session Court and Magistrate Court. As you can see here in the pyramid, High Court of Malaya and High Court of Sabah and Sarawak, Session Court and Magistrate Court are court that have in every state. And from here, you cannot see the Sharia court since it is not under this jurisdiction because it is cover only matter that related to Islamic law. So we will proceed on the Federal Court. Federal Court, as you can see in the pyramid, is at the top of the pyramid. So it is the highest court in Malaysia. And the original jurisdiction is to determine validity of any law made by Parliament or any legislation. So it also can hear or appeal from Court of Appeal and High Court. So the next one is Special Court. Special Court is a court that specifically hear civil or criminal action against or made by Yang di-Pertuan Agong or any of the 9 Malay rulers. And then we'll proceed on the Court of Appeal. Court of Appeal, we determine appeal from the decision of High Court in civil and criminal cases. And the next one is High Court. As you see in the pyramid, High Court consists of High Court of Malaya and High Court of Sabah and Sarawak. If in Peninsular Malaysia, it is under the jurisdiction of High Court of Malaya. Meanwhile, High Court in East Malaysia, jurisdiction of High Court of Sabah and Sarawak. So, what's High Court function for is, first, for criminal jurisdiction, High Court will hear criminal matter involving death penalty. Meanwhile, in civil jurisdiction, High Court will determine all the civil matter which are beyond the jurisdiction of the Session and Magistrate Court. So the claim amount that involved is exceeding 1 million. High Court can hear the case that related to divorce and matrimonial matter, admiralty, bankruptcy and company civil dispute, the appointment and guardianship of infant and the property, the appointment of guardianship of the disabled person and the property, and letter of administration and probate issue. So and the last one is for appellate jurisdiction. High Court will hear criminal and civil appeal from the Session and Magistrate Court. So we proceed with the second last court, which is Session Court. Session Court is under a subordinate court, and in criminal jurisdiction, Session Court will hear all criminal cases except for the case that subject to death penalty because this is under the case that subject to death penalty is under High Court. And the second one is under civil jurisdiction. High Court will hear all civil cases such as exceeding claim, dispute between the landlord and tenant, and the amount that claim is up to more than 100,000 ringgit, but not exceeding 1 million. And the last one is Magistrate Court. Magistrate Court also under subordinate court. It will hear criminal jurisdiction. It hear all criminal offence which subject to the fine and imprisonment not exceeding 10 years, or fine and may sentence not exceeding 5 year imprisonment, fine not exceeding 10,000 ringgit, and or 12 times of whipping. And under civil jurisdiction, the amount that can claim under magistrate court is less than 100,000 ringgit. So, and the last one, I will explain about the civil and criminal fraud trial. For information, individual that commit fraud can be prosecuted by criminal, civil, or both criminal and civil. So, the defrauded company must decide whether to pursue the case as criminal, civil, or both, or no action taken at all for the case. But most of the company decided not to bring the case to the court, since it will give the negative impact to the image of the company and it will cost them more. So what the company usually do is they will fire the perpetrator, or they file a claim with a fidelity bonding company. So what is fidelity bond? Fidelity bond is an insurance contract that taken by employer in order to protect from employee doing fraud. So that's all from me. Thank you.
In this part, we will present about the two types of legal follow-up process. Firstly, civil litigation process. The civil litigation process involves 4 stages. Firstly, filing and closing pleading. Second, pre-trial case management. Third, trial. Fourth, post-trial submission. Next, for the stage 1, the filing and closing pleadings. A civil action is generally commenced by the filing and service of a will. A defendant then has 14 days to enter appearance to dispute the action. If no statement of claim was filed with the will, the plaintiff has 14 days after the entry of the appearance to file and serve the statement of claim. The defendant has 14 days to serve a defense and counterclaim, if any. Thereafter, the plaintiff has 14 days to file a reply to the defense and a defense to counterclaim if required. Pleading will be closed 14 days after the plaintiff serves a reply to the defense, or if not reply is served 14 days after the defense and counterclaim are served.
Now I will continue with the stage 2, pre-trial case management. After settle the stage 1, the action will be set down for the pre-trial case management, where direction will be issued by the court to prepare the matter for trial. This will be take approximately 2 to 3 months. So, for the case management is a meeting between plaintiff and defendants. Next, I will continue with the stage 3, which is trial. A trial is a fact-finding process before a magistrate or judges third stage, which is trial. A trial is a fact-finding process before a magistrate or judge where a decision is made in the case. Plaintiff is a person who bringing the action in the court, while defendant is the person being sued. Plaintiff has the burden of proving his or her case. The plaintiff calls his witness to give evidence during the examination in chief. This witness will be cross-examined by the defendant and later may be re-examined by the plaintiff. The defendant also calls his witness and has the burden of raising providing any defences he may have to claim it. Once the both parties have completed their task, they will be asked to give their submission. Next, we will continue with stage 4, which is post-trial submission. In the post-trial submission, at the conclusion of the trial, a decision is pronounced in open court. A decision is a judgment or order which is pronounced immediately at the conclusion of the trial or none some other days. Prior notice to attend will be given to the parties if it is derived on some other days. Next, the part 1 process of legal follow-up is criminal litigation process. This involves 6 stages. Firstly, arrest and investigation, remand proceedings, charge and bail, pre-trial case management, trial and post-trial. 1. Arrest and investigation. The criminal justice system in Malaysia recognizes 2 types of offence which the police may arrest with or without warrant. In a case where arrest has been made without warrant and categorized as seizable offence, the police may proceed with investigation of criminal offence without prior order to investigate from the public prosecutor. The police have 24 hours to complete the investigation, which thereafter the investigation paper should be referred to the public prosecutor for the further direction. If the investigation cannot be complete within 24 hours, the police may apply to the court for the suspected person be remanded under section 117 of the Criminal Procedure Code. During the arrest, the suspected person may request and inform the police that he has the right to be represented by a lawyer before the start of questioning or recording any statement from the suspected person. Any questioning and recording of any statement by the police should be deferred until the consultation with the lawyer has been made. Stage 2, remand proceeding. After the expiration of 24 hours from his arrest, the arrested person should be released forthwith. However, the police may apply to the court for the suspected person be remanded beyond the 24 hours in order for the police to complete the investigation. In most seizable offence which carry imprisonment of less than 14 years, the magistrate may make an order to remand the suspected person up to 4 days on the first application and should not be more than 3 days on the second application. For offence punishable with death or imprisonment of 14 years or more, the detention should not be more than 7 days on the first application and should not be more than 7 days on the second application. At this stage, a lawyer can be appointed by the suspected person to oppose the remand application by the police. Appointment of lawyer should be made properly and possibly the minute the suspected person arrest and brought that to the police station. Stage 3, charge and bail. Soon after the period of remand has been expired, the criminal charge will be read and explained to the accused person. If the accused person does understand the accused person does understand the nature and consequence of the charge, the accused person is entitled to enter a plea. You have the right to be represented by a lawyer when the charge is read. Should the accused plead not guilty to the charge, the lawyer will request for bail application. For the bail application is when the court will hear submission from the accused lawyer whether the accused may be released from custody upon payment or security deposit to the court. The payment of sum of money to the court is form of security taken from a person to appear on a fixed date before a court. And however, some offence the law exclude the person right to the bail. Hence, he should be further detailed until the completion of the trial. Next, if the court grant the bail application, the accused will be released from custody, but the criminal case is not over yet. The accused should compulsory attend every hearing mentioned and trial of the case on the date and time fixed by the court. Failure to do so will result the security deposit forfeit and warrant of arrest will be issued against the accused person, and if demands necessary to the person should stand as bail to the accused. The fourth stage is pre-trial case management. After the bail proceeding, a new date will be fixed for the case management. All relevant document and evidence to be used by the prosecutor in the trial will be given to the defense lawyer. Stage 5, trial. The trial begins with the prosecution calling their witness and presenting their evidence to the court. The prosecution at this stage is required to discharge a burden of providing their case beyond reasonable doubt. If the prosecution fails to establish a prima facie case, the court will discharge and acquit the accused. The last stage, which is post-trial, in the event the accused person is found guilty, the court will sentence the accused person according to the prescribed punishment. Before sentencing, the lawyer will have a chance to ask for mitigation, example like the sentence. After sentencing, the lawyer may also ask for a stay of execution pleading appeal to the appellate court. That's all from me. Thank you.
Good day everyone. My name is Hwong Hui Lin, matrix number 256202. I would like to present about the part 2, which is be in an expert witness. Okay. Now I would like to present about the definition of expert witness, which is person whose opinion by virtue of education, training, certification, skills and experiments is accepted by the judge as an expert in a court case. The expert witness may deliver expert evidence within the area of their expertise. They also present in litigation to explain complicated scientific issues, not to influence the judge with favor. Expert opinions must be based upon sufficient facts or data and relevant and reliable principles or methods. Okay, next. How to be an expert witness. The fraud examiner and accountants are often retained as expert witnesses in both civil and criminal cases. Most witnesses in a fraud trial are fact or character witnesses. The primary function is to express their independent expert opinion based on information that is provided. Then the role of the expert witness. The expert witnesses are called upon in the court system to serve as an objective party to the lawsuit and never function as an advocate for one side or the others. Okay, next. I would like to present about the process of qualifying an expert witness to testify. The judge will rule whether an expert witness can testify about the first. There's 5 aspects, which the first is the nature of fraud. Second, the damage suffered in the fraud. Third, the negligence of the victim in allowing fraud to happen. Fourth, standards. The example is given is accounting standards that are violated. Then the last one is other aspect related to fraud. Next slide. At discover stage, the expert study facts of the case. The preparation involved reading the position of witnesses, thinking analytically about the cases, studying timeliness, and doing all you can to understand the facts of cases. Okay. In most cases, fraud experts are asked to be either damage expert or liability expert or both. Then the damage experts make assessment of the damage to their site, including suffered damage. Then for the liability exercise, the liability exceptions are tricky because they are offering the opinions about who are culpable, who committed the fraud, who should be detected the fraud, or who had some kind of liability. Okay. Then the expert witness also will prepare the reports that set out their opinions. After discovery periods ends, experts are deposed at attorneys on the opposite sides. That is more stressful part. The attorney is something like lawyer. Okay. During the depositions of expert, attorneys aim at understanding the expert opinion on the case, understanding expert credentials and experience, identify evidence that can either impeach expert or used against his testimony during trial, assess how difficult an opponent the expert will be. Okay, next slide. During the deposition as expert witness, we have 5 steps. Okay, the first step is take a defensive posture. The expert witness also must answer only the questions that are asked in most abbreviated way. The expert witness also must listen carefully to questions before answering. Then pause before answering to give attorney time to object to question on the basis of relevance, foundations, or other basis of objections. Then we must remember to give an honest opinion at all times, not selling it to be the highest bidder, the preserve reputation and integrity. Next slides. For the last slides, I would like to present about in conclusions, that an expert witness perform a forensic accounting investigation where with the help of an economy analysis firm. The second, an expert also examines the bank and others' records to follow the money, the transactions, and the flow of goods. Then the last one is an expert use an economist analysis firm as support to calculate real, what if, and pre-judgment interest damage using the assumption that were different from the assumption and damage the plaintiff expert had calculated. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. This is Sofiyyah 551. I'm going to present the part of the topic 8, which is a general list for evaluating and inspection. The 10 generally accepted auditing standards are broken into 3, which is 3 general standards, 3 framework standards, and 4 reporting standards. Firstly, we are going to look into general standards. In the general standards, the auditor must have adequate technical training and proficiency to perform the audit. The auditor also must maintain independence in mental attitude in all matters relating to the auditing. The auditor also must exercise due professional care in the performance of the audit and the preparation of the report after finishing the audit. Next is the standards of frameworks. In these standards of frameworks, there are 4 keywords, which is plan, supervise, understanding, and evidence. The auditor must adequately plan the work and must properly supervise any assistant. The auditor also must obtain a sufficient understanding of the entity and its environment, including its internal control, to assess the risk of making a misstatement of the financial statements, whether due to error or fraud, and to design the nature, timing, and extent of further audit procedures. The auditor also must obtain sufficient appropriate audit evidence by performing audit procedures to afford a reasonable basis for an opinion regarding to the financial statements under audit. Next, we are going to look into standards of reporting. In the standards of reporting, the auditor must state in the auditor's report whether the financial statements are presented in accordance with generally accepted accounting principles. The auditor also must identify in the auditor's report those circumstances in which such principles have not been consistently observed in the current period in relation to the preceding period. When the auditor determines that their disclosure are not reasonably adequate, the auditor must so state in the auditor's report. In the auditor's report, the auditor must either express an opinion regarding the financial statements taken as a whole or state that an opinion cannot be expressed. So, the do's and don'ts at deposition or trial. There are 13 lists of things that the do's and don'ts at deposition trial. The first one is to listen carefully. The second is to think about the question and digest it before attempting to respond. Don't try to guess or bluff your way through an answer. Do restrict your answer to the question asked. Don't respond to statement of observation, only to questions. Do answer question convincingly. Don't repeatedly attempt to hedge your answer or be efficacious. Don't memorize answer to question you expect to be asked. Do phrase your response in your words. Do answer question honestly. Do speak out the answer to each question cautious before answering any hypothetical question. Do try to read messages intended by objections to question by the lawyer with whom you are working. Don't hesitate to take the time necessary to review exhibits presented to you before responding to questions based on them. Do explain all assumptions on which your conclusions are based and do prepare for opposing counsel to attack them. The next table of 18.2, there are additional don'ts and don'ts at trial. The first one is don't be mindful that your personal characteristic and professionalism may influence the jury. Do be yourself. Do your best to appear authoritative. Don't appear pompous, aggressive, insincere, or unfair. Do remember that You are independent. Do focus on the lawyer asking questions. Do correct any errors you make as soon as you can. Do tailor your answers to the jury educational level and do your best to speak in plain English. Don't bore the jury. Don't hesitate to raise your voice. Don't speak just loud enough. Do speak just loud enough and just fast enough to be comfortably understood by the jury. Don't bring notes, put papers or other material to the witness. Don't try to play lawyer while on the stand. Don't look to counsel for your side or the judge or anyone else to bail you out if a question stumps you, or you otherwise get yourself into a hole. The last table is table 18.3, which is do's and don'ts in cross-examination. The first one is don't lose your temper or become angry or antagonistic. Don't be concerned if opposing counsel scores points. Don't prefer unduly or become argumentative with opposing counsel. Don't respond evasively or ambiguously to questions, no matter how difficult they may be. Don't be careful if opposing counsel takes unfriendly air. Don't become hostile if opposing counsel tries to bully you. Do resist responding with simple yes or no answer. Do your best to recognize signals. Don't allow opposing counsel to entice you into answering questions that concern matters outside your area of expertise. Do maintain the position you took in your direct testimony. Don't allow opposing counsel to con you into an advocacy role. Next is the cases that related to fraud. The first case that our group found is Taib Mahmud's son's says wealth exaggerated express claim from group investigators. The Taib Mahmud's son, which is Abu Bakr, is having accused by his ex-wife that he having shore out billions of ringgit domestically as well as abroad. This information she's getting from the court investigators that based in Canada. Based on this information, the Taib Mahmud's son ex-wife claims and exaggerating for his wealth. The next cases that related to fraud is the audit of farmers body finds 7 violations involving RM 15 million losses. In these cases, which is a forensic audit from the forensic audit that did the audit on the National Farmers Organization, which is NAFAS, have found 7 items that were questionable and had violated by the against financial and administrative procedure that caused a loss about RM 50 millions. The chairman of NAFAS, which is Fahrul Razi Muhammad Zawawi, disclosed that the findings were based on forensic auditing of accounts that conducted by an international audit firm from May to September last year. This is involving the misconduct under the previous board of directors. The chairman of NAFAS said that among the irregularities and violation were the purchase of 40,000 tons of fertilizers in 2017 from external suppliers, and this action is without no supporting documents for the purchases. And standard procedures were not followed during laboratory test sampling and when the stocks were delivered. And This is one of the proof that the agency have violated the procedures of this agency. That's all from my part. Thank you.
Okay, hi. I would like to present about the discussion question 13, which is page 628. Okay, the question is, what are the sum of the do's and don'ts of being an expert witness? Okay, we look about the do's of being an expert witness. The first one is provide an independent expert opinion in their areas of expertise on the subject matter in accordance with the instructions that are given. This instruction will be shown in the expert witness report, which will be seen by the other side and the courts. The second one is to provide the opinion in the form of reports and evidence before a court as required. The report is required as it is not usually possible for the expert to give evidence without it. The third one is comply with the specific procedure rules applicable and any court or tribunal's orders in the case. The fourth one is provide truthful, impartial, and independent opinions whether or not these opinions favor your case. The last one is the court expect an expert witness to be independent and impartial and will discount the evidence of one who is or is seen to be partisan. Okay, the next one is for the don'ts of being an expert witness. Okay, also have the 6 don'ts. The first one is provide any opinions beyond their specific areas of expertise. Then the expert witness will not provide the advice. Then there will not accept any appointment which involves a conflict of interest unless resolvable by disclosure. Then they will not act as a negotiator. Then not provide detailed instructions. Then will also not keep the expert informed of developments in the case and of all key steps in good time. Okay, that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Sofiyyah Binti Shaidee. My matrix number is 25551. Next, I'm going to discuss on question 14 on page 628 in the textbook. The question is, what types of fraud liabilities can an expert witness testify on? My answer is many types of cases where fraud experts can be excellent expert witnesses, such as financial statement fraud, Ponzi schemes, vendor and customer frauds, and other types of fraud cases. Other fraud experts have testified in bankruptcy cases, divorce cases where assets have been hidden, tax cases, business valuation cases, accounting theory cases, and other financial related cases. That's all. Thank you.
So we will proceed on the last question, which is debates 1, page 634. The question is, Sam Electronic Universe has discovered and investigated a kickback fraud perpetrated by its purchasing agent. The fraud lasted 8 months and cost the company $2 million in excess per inventory purchases. The perpetrator personally benefited by receiving kickback of $780,000. Your boss wants to seek restitution of what the company has lost, but is worried about the ramification of a trial and its impact on your company image in the market. She is trying to decide if she could pursue remedy through a civil trial or turn the cases over to the district attorney to prosecute the perpetrator criminally. Pair up with somebody and choose side. Discuss the pro and con of each approach of legal follow-up to fraud. So from here, what I understand is that it can be through two approach, which is the first one is with trial and the second one is without trial. So if they decide to resume the cases with trial, the pro and con is it will incur more additional expense, the trial will be lengthy and it will leave negative public exposure, but the trial will result to a fair punishment. And the second one is having the case settle the case without trial. The pro and con is the company can save the trial cost and they can settle the cases immediately. And lastly, they only can claim the amount up to the amount that they had lost. So that's all from Group 8, and thank you.